Good afternoon to everyone. We are streaming live on, well, Paul Boy, I have to throw you under the bus. I have to say Paul Gans, ITFX streaming platform. My name is Bayliss Frederick, and with me is the president of the bar, Sherlyn Zita Barnwell. We are having Law Week 2025, and today is the inaugural Memorial Moot Court Competition, the J.H. Bayliss Frederick Memorial Moot Court Competition, sponsored by Frederick's attorneys under the auspices of the Bar Association of St. Vincent and the Grenadines. And we're streaming live, as I said, but Zita, Madam President, how has the week been going?
Well, Vinod, thanks for actually hosting this event and for sponsoring this event. Well, your Law Chamber. Law Week, this is since the new executive was elected about 2 years ago, almost 2 years ago. This is our second annual Law Week. And we started on Sunday with the church service at Kingston Baptist Church at Montrose. And I want to say publicly again, thank you to Pastor Richards for hosting us. And on Monday, we appeared live on Voices program hosted by Jomo Thomas. Mm-hmm. And on that program, myself, Max Ron, who is the chair of the Law Week.
Yes.
And also we have Assistant Commissioner of Police, Mr., as we call him, Buju Bailey. Buju Bailey. It was an awesome program. And earlier in the day, we visited, I can't remember my head, but this year we attempted to, and there's a reason why I said attempted to, visit about 5 schools and 5 rural schools. Last year, when we held Law Week, we visited 7 schools, including the community college, and those were the schools in and around Kingstown. And we thought that we must visit the rural schools this year. However, we were able to visit some. Mm-hmm. Our goal was to visit at least 6, and I believe we visited 4.
4, yes.
Right. And on Wednesday night, I believe that's when we had Beverly East.
Yes.
Right. The handwriting specialist, as we say, on a session that was basically a closed session, training session. Right.
Yeah. And police.
That's right. And the police, continuing legal professional development. And that was on a session on forensic document assessment.
Yes.
Right. And yesterday, Thursday evening, during the day, I believe you visited North Union School.
Yes, perhaps North Union Secondary School, and Beverly East also visited the St. Vincent Girls High School.
Right.
Spoke with the prefect body. It was very well received. North Union also well received. We spoke to third and fourth formers at North Union. There's a lot of need for, there's real need for lawyers to reach out. That was my takeaway.
I agree.
We do need to get into communities and talk to young people, especially about how the potential for the law to impact them. That was Thursday. That was Thursday in the day.
Right.
And then in the evening, Justice Westman James.
That's right. An awesome session.
Wonderful.
And that was on the ethical use of AI in our practice as lawyers. And that session, we had almost 104 persons logged on, and that's throughout the entire region, throughout the OECS region that logged on to that session. I also want to say thank you to all of the schools that participated, and I am giving a special shout out to a school that are my favorite this year, which is Bethel High School. Those students were really awesome. I think sometimes we underestimate the intelligence of students simply because they go to schools that are branded in a particular way, unregrettably. But those students were really, really engaging with the material and, asked lots of questions and were very excited. In fact, I saw about 5 of them yesterday in the evening who recognized me and greeted me so warmly. So, we still have some hope here for those students. So sometimes we sort of leave by the side simply because we think they're not going to a top-tier school. And you are so correct that the Bar Association needs to do more community engagement, in particular with schools, to teach our young people about their rights.
Yes. Well, I just say the acting DPP coming into.
Yes, Mr. Daniel, we want to invite you to say a few things. Part of this is a community engagement. As the
Yes,
on.
we are streaming live, so
We
we're
are
just
streaming
giving an
live.
overview.
You are
Yeah,
streaming
we are
live.
streaming live online, and
Come on, Mr. Daniel. Have a seat here. Let's have a talk
we
about
we are receiving that. We are receiving messages about the lawyers who are on their way and coming. But who we do have present are 4 young people who will compete in the Moot today. It is a criminal appeal moot, and we have the Chief Justice and Justices of Appeal in the persons of our very own High Court judges, the learned Justice Ricky Burnett, in whose court we are now sitting, and with him, the learned Justice Sanak Dantes, and they are both being joined by Senior Magistrate Tamika McKenzie, and they will form the quorum of the court, the panel that will hear from 4 students of the community college, 2 representing those doing paralegal studies, and 2 representing those doing CAPE. And they've been preparing for a couple of weeks now. They've done memorials. Their written submissions will be judged by the judges, and then their oral arguments will also be judged by the judges, who will also be asking questions.
Counsel Frederick, if you'll permit me, I noticed that you said that the advocates for this evening will be heard by the panel and quorum for the Court of Appeal. I'm a little confused as to how they intend to be heard, considering I don't see them wearing robes.
Yes, we didn't. We
Yeah,
asked
I
them
don't
not.
see-
We asked them not to robe. We asked them not to robe because this we didn't want to put them in the expense of finding their own robes to fit them.
I see.
So we asked them. We asked the judges to accept them being heard as they are.
Okay, but I'm just anxious to have them disabused of the belief that they can actually be heard in the absence
Of
of
robes.
wearing a robe.
I think
Okay.
they're nervous enough. Learned DPP. I think they're nervous enough. Don't panic them even more.
Well, I don't mean to scare them, but I see Justice Sinak Dantis is here now.
Preparing
And
her
Yes, I
microphone.
see that she's preparing. So if they were to be scared, I hope they know that this is the most fearsome judge that we have in the states of St. Vincent and the
Yes.
Grenadines. So I was hoping that they would be robed so that the blood splatter wouldn't really necessarily get on their fine vestments.
Yes.
And it would have been sheltered
Just
by
pay
the robe.
close attention to her laser vision. Yes, it's potentially very damaging. Just pay
Yes.
close attention, young people.
Yes, and clearly she's arming for a war there. She has she has her armory. She's arming for war. Yes, so we're seeing,
We have awards. We also have victuals for the young people after they've been bludgeoned here in the court. We help them to resuscitate by I Cater Foods catering this evening. We are streaming live, as you know,
it's
very much live.
it's video and audio.
Everything. So you are very much going across to the
Oh,
world.
hold on! You didn't tell me to suck in my belly. You didn't tell me. It's busy.
You're live, you know.
I hear that. Well, you should
Yeah.
have told me it was video. So I was asking when I was crossing if there was video. So then I would have known too.
Yes, and
Where's
so
the camera? Oh, the camera.
there
Oh,
are
is it?
several cameras in
I
the
saw
court.
that camera there. Oh, okay.
Yes.
So I angle my belly in particular if I sit a little taller.
And
Okay.
so the young people and those persons looking will see the inner workings of a refurbished court and vast improvement. Yes. Oh,
Okay,
wait,
well,
let me suck
I'll
in my
hide-
filter here.
Yeah, oh yes, I just see myself now. Hold on, let me see.
Smaller.
Yes. Okay, well, let me pass the mic back to Madam President while I familiarize myself with the fact pattern.
Yes.
Well, I thought that Ms. Frederick was going to ask you to give a few encouraging words, as you're one of the most fearless advocates that we have here, and you walk across the civil court as well as the criminal court. And perhaps you can, give them a few words of encouragement before we start here today.
Well, all I could say to the young advocates is that you are to make sure that your presentations are respectful. You are to make them directly to the panel, and you are to make sure that you accord the other side the utmost respect they do not deserve.
That last part of his advice is to be struck from the record. That is certainly not true.
Yeah, we're going to start.
So we are about to start, Ms. Frederick?
Yes,
Okay.
we're about to start.
Thank you, Mr. Daniel.
And following on online and to those who are present, the fact pattern, so you know the backstory. It's a criminal appeal, number 1 of 2025, between Shane Beckford, the appellant, and the Queen, the respondent. Shane Beckford was charged, along with Becky May, with the murder of Stacey Beckford, the appellant's wife, on the 1st of August 2024. Shane and Stacey were going through divorce proceedings. Shane wished Stacey to leave the house so that his new girlfriend, Becky May, could move in, but Stacey refused to leave. Shane and Becky subsequently devised a plan to scare Stacey into leaving the house. It was led in evidence at the court below that Becky was a woman of violent disposition. She was recently released from Her Majesty's Jod's prison for assaulting her previous lover's ex-wife with a tree saw. Becky attacked the woman because, according to her, she was a threat and needed cutting down. Shane knows of Becky's criminal history as well as the fact that Becky sees Stacey as a threat. At trial, Shane admitted that there was an original plan to scare Stacey out of the house by pretending to burglarize the home while Stacey was home alone. Stacey had previously told Shane that because of the recent chain of robberies occurring throughout the neighborhood, she was afraid to be alone in the house and she feared for her safety. Shane and Stacey had visited Stacey's doctor earlier that week and were informed that Stacey was suffering from a defective heartbeat and should refrain from strenuous or overexciting activities. Becky and Shane devised a plan to wear black masks and carry a fake gun to burglarize the home and scare Stacey. Shane further admitted that subsequently Becky altered this plan and he knew Becky's gun was indeed real and that she intended to kill Stacey instead of merely scaring her. Stacey was in the kitchen preparing dinner when the pair entered the house. Becky walked up to her and shot her 3 times in the chest. Stacey fell to the ground and the duo fled the scene. Shane submitted that he only went along with Becky's new plan to kill Stacy because after confronting Becky about having a rare loaded gun, which was not a part of their original plan, Becky threatened to get one of her prison buddies to snap his neck if he refused to go along with the new plan. Shane began to drink after Becky threatened him. He argued that at the time of Stacy's death, he was really drunk and could remember nothing of what had occurred, and that in any event, he had never intended Stacy Beckford's death. He merely intended to scare her. He would never intend to kill his wife. Medical evidence showed that Stacy died as a result of the wounds inflicted by the gunshots. Becky May and Shane Beckford were convicted of murder. Shane Beckford appeals on the following grounds. 1. When directing the jury on the mental element of the crime, Justice Harshwise misdirected the jury in stating, members of the jury, don't be fickle. Did Shane intend to kill or cause grievous bodily harm? If you think Shane knew very well, as we all would, that it was entirely probable that his acts would result in death or serious bodily harm, well, you must take that into account, and so you may decide that he must have intended these acts. Also, if you think he knew that death or serious bodily harm was virtually certain, well, then you must decide that he intended those results. On the issue of participation, Justice Harshwise, this is ground 2. On the issue of participation, Justice Harshwise had misdirected the jury-in-law by suggesting that, you see, they were in it together, weren't they? Do you think? They both took part in the killing. They were engaged in a common design. So if you think that Shane, like any other reasonable person, must have foreseen that Stacy would suffer real serious bodily harm, then he was engaged in a common design with Becky. Becky is known to be a violent woman, and it could reasonably be foreseen that she would try to harm Alice in some matter. Any reasonable person could see that. Further, by going ahead with the new plan, shows he accepted the change in their common design. How then can he say that he didn't intend Alice's death? He made no steps to stop this new plan. Thus, he must be held liable for the consequences of these acts. And the third ground, on the plea of intoxication, Justice Harshwise told the jury only, Shane cannot voluntarily become intoxicated in order to give himself the courage to commit the acts and then rely on the same intoxication to demonstrate that he lacked the mental requirement for the act. Was he, Shane, really without any knowledge of what was going on? Or didn't he want to know? Was he afraid? Did he take to drink to give himself the courage to kill? To ease his mind from what he knew very well was going to happen? You don't have to be a genius to work it out, do you? But you decide when he took to drink, is his voluntary intoxication, in your view, sufficient to reduce his conviction? And fourthly, on the issue of duress, Justice Backslide misdirected the jury when he said, now he says he was compelled to take part by threats, but he knew all along, didn't he? He admitted that he knew Becky had a violent past, and it is reasonably foreseeable that she would have violent associates. Shane cannot associate himself with a known criminal and induce stress as a defense when she resorts to her known violent ways. In murder, duress is no defense anyway, and this is a murder case, not a manslaughter case, nor anything else. Now, there's a disclaimer, which I don't think is necessary to read for the public. Just as it relates to the guidelines, the young persons have written submissions to the court. Let me just amend. The appeal is between Shane Beckford, the appellant, and the king, right? We have a king as the head of state and not a queen. And the second amendment is the name of the wife is not Alice, it's Becky. And the name of the judge is Justice Harshwise, not Justice Backslide. So we make those amendments. In relation to the rules, the young persons would have submitted for the attention of the panel memorials, which are submissions. Their written memorials will be judged. And as well as so there's going to be a prize for the best written memorial, and they're also going to be judged on their oral submissions. And they've been given these rules, okay? I don't want to waste the time of the viewing public by going through the actual rules. The judges have the rules of the competition, so just support these young people, and let's hear the arguments for the appellants and the respondents. I will now ask the bailiff to open the court.
His Lordship. The Honorable President and the other justices of appeal of the mock appeal. Supreme Court in its appellate jurisdiction now opens.
Yes.
Case number 1 of 2025, Shane Beckford and the Queen.
King.
And the King.
Appearances, please.
My lord, my ladies, my name is Ashanka Bilinji, and with me is my co-counsel, Miss Mayfair Monroe, and we appear for the appellant, Mr. Shane Beckford, in this matter. I will be addressing you for 5 minutes, and my co-counsel, Miss Monroe, will be addressing you for 5 minutes, and we reserve 2 minutes for rebuttals.
Yes, thank you, counsel. For the respondent.
Good evening, my lordship and my ladyships. I am representing the respondent, the King. I am Miss Rain Oliver Ging, and my co-counsel, Mr. Sean Slater.
Sean
Slater,
Slater.
yes.
Thank you, counsel. All right. May we hear from the appellant at this time?
I will be addressing our first 2 submissions, that is whether the trial judge misdirected the jury on the mental element of murder, and whether the judge properly directed the jury on the appellant's liability as a secondary party.
Yes, thank you, counsel.
Now on to my first submission. According to section 159, any person who with malice aforethought causes the death of another person by an unlawful act is guilty of murder. Malice aforethought shall be deemed to be established by evidence proving either an intent to cause the death of or to do grievous bodily harm, or knowledge that the act or omission causing death will probably cause the death of or do grievous bodily harm to another person. In the case of R.V. Georgie, it was held that mere foresight does not satisfy intent, and merely foreseeing that a crime may happen is insufficient to establish guilt. In the present case, Shane admitted that the original plan was to scare Stacy, not harm her. This suggests a lack of intention. Although he became aware that Becky intended to harm Stacy, he neither agreed to this change nor supported it. The trial judge misdirected the jury by stating that Shane must have known that the consequences were probable and they should infer intent. This blurs the legal standard that mere foresight does not satisfy intention. Now on to my second submission. In the case of R. and Anderson and Morris, it was held that where two parties embark on a joint enterprise, each party is liable criminally for acts done in pursuit of the joint enterprise. But if one party departs from what was tactically agreed as part of the joint enterprise, then the other is not liable for the unauthorized act. In the present case, Shane agreed the plan was to frighten Stacy, not kill her. Becky deviated from the original plan by using a real gun and harming Stacy. Therefore, Shane is not liable for the unauthorized act. The judge misdirected the jury by applying the wrong test for joint enterprise. The proper question is whether Shane, at the time of his actions, intended to assist Becky. If I can be of no further assistance to the court, my co-counsel, Ms. Monroe, will submit her third and fourth submissions.
Just before you leave, counsel, let's engage you for.
Okay.
Yeah, I see.
Counsel,
Yes.
your last submission is that the judge misdirected himself. He applied the wrong test. What is the test that he should have applied? And the authority, please.
The proper question would be whether Shane, at the time of his actions, intended to assist Becky.
And the authority?
That I cannot provide at this time.
Can I ask you, counsel, in relation to your first address on the mental element, are you seeing in your submissions, are you saying that the trial judge's reference to must have known amounted to a legal misdirection or merely poor phrasing?
Legal misdirection, because
Elaborate on that.
according to the case of R and Georgie, it was held that merely foreseeing something does not infer intent. Instead, it proves that there was just mere evidence.
Is it not the same Jogi that says that if you know that the intention of the party and you choose not to deviate from it, then you're part of the enterprise?
The appellant acted under duress, which my co-counsel will address later.
But counsel, in your written document that you sent to the court, you stated that this blurred the legal standard. Yes? How did the judge direction blur the legal standard? Page 5 of your memorial.
The judge blurred the legal standard by leading the jury to believe that foresight just infers intention.
Okay.
So what would a proper direction have looked like, counsel?
Instead, he should have asked if the jury thinks that Mr. Beckford at the time intended to assist Becky in her plans.
Would you consider this misdirection significant enough to affect the jury's verdict?
Yes,
Why do you say that?
because the jury ruled based on the fact that the judge told them that they should infer intent based on Shane just foreseeing that the acts may be probable.
All right, thank you, counsel.
My lord, my ladies,
Yes.
my name is Mephia Monroe, and I will continue the case of the appellant. We contend that the trial judge misdirected the jury on two crucial aspects of law: intoxication and duress. The evidence presented in the trial, along with Shane's lack of memory and excessive alcohol consumption, strongly suggests that he was incapable of forming the needed mens rea for murder. Under Section 11 of the Criminal Code addresses intoxication on criminal liability. It lawfully states that intoxication shall not constitute to a defense. However, it also states that intoxication shall constitute to a defense if by reason thereof at the time of the act or omission complained of, the person did not know that the act was wrong or he did not know what he was doing. Shane's intoxication was induced by Becky's threats, and it may have negated the mens rea for murder. The jury needed to understand that if Shane, due to his intoxication, did not have an intent to kill his wife, Stacy, he shall not be guilty of murder. A case I can rely on for the defense of intoxication is R and Sheehan and Moore. Sheehan and Moore, in this case, were very drunk, and they threw petrol over a man and lit him on fire. They then went to court and the jury saw that they complained that intoxication should be used as a defense and that they had no intent to kill the man. Now on to my fourth submission on whether Mr. Beckford can rely on duress as a defense. The defense of duress is central to this case. Shane argued that he acted on the duress due to threats from Becky. The law recognizes duress as a valid defense in certain circumstances. A crime is when the crime is committed, a person can only be guilty except for on the murder as a principal offender, genocide or treason. If they commit a crime only because they were compelled to do so by immediate threats of death or serious harm to themselves or their close family members who are present, future threats do not count. The trial just erred by suggesting that Shane's knowledge of Becky's violent tendencies automatically barred the jury of duress. A case I can rely on for duress is the case DPP Northern Ireland and Lynch. Lynch was forced by IRA gunmen to drive to a secluded place where they killed a police officer. He argued that he was forced by threats from the IRA gunmen and he was fearful for his life. That is why he did so. The jury in that case says that he The correct test as established in the case R.V. Garham requires the jury to consider both objective and subjective elements. Objective elements, would a reasonable person have committed the same? Subjective element, was the person compelled to do so? Now, if it may please the court, may I move on to my prayer of relief?
No.
Yes, Counsel.
In the light of all these misdirections, we contend that the conviction of Shane should be overturned. The judge's failure to do. We therefore request that this court overturn the conviction and consider a retrial. Yes, please.
I want to know how she distinguishes the Sheehan case.
We have a question for you.
So, counsel, you said to us that the case of Sheehan and Moore, in that case, that they voluntarily became intoxicated and thereafter they went to commit the crime. How is that different from this one, where Shane did the same thing?
In the case of R and Sheehan and Moore, they did both cases. They chose to be voluntarily intoxicated, but however, Shane, alike as Sheehan and Moore, did not have any memory of what happened, and the mens rea for murder could not be sustained.
So would you agree with me or disagree in terms of the voluntary intoxication of Shane in this case? He had the intention before he became intoxicated and then carried out the act. How is it different? I'm not getting that clear.
Shane, due to threats from Becky, decided to voluntarily intoxicate himself because it was very overwhelming. He had no intention to kill his wife, Stacy. He just wanted to scare her.
So are you saying, counsel, that the direction was flawed in content or in tone?
Sorry?
Was the direction flawed because of content or of tone? What are you saying?
She not listening.
Content.
And in the direction which the judge gave, based on your submission, you vindicated that you drank for courage. Am I accurate? Is that a correct assessment?
No, he didn't. He did not drink for courage.
I've misread that.
All right, thank you, counsel. May we have counsel for the respondent at this time?
May it please the court, I appear on the behalf of the respondent, the King. I will be addressing grounds 1 and 2 concerning intention and participation.
That's Counsel Oliver.
Yes, Oliver Gill. Yes. The respondent submits that the trial judge's directions were sustainably correct, that the conviction for murder is safe, and that the appeal should be dismissed. My lords, the appellant argues that the trial judge equated foresight with intent. However, the direction was substantially consistent with R.V. Willen 1999, which provides that foresight of death as a virtual consistency is evidence from which intent may be inferred. The appellant admittedly knowingly that Becky carried a real firearm instead of the original fake one in the plan they had first created. He broke into the house and decided to. He broke into the house knowingly that Becky had the firearm. Despite of the knowledge, he accompanied her into the house and participated in the plan. The conduct demonstrates consistent acceptance of death and its a likely outcome. Even if the judge's wordings were imperfect, any misdirection was not material. The evidence of intent was overwhelming, and the jury would inevitably have reached the same conclusion. Turning to my second submission, the appellant contends that the judge misdirected the jury on the enterprise. Respectfully, the law as stated in R.V. Jorge confirms that intent to assist or encourage may be inferred from content. In this case, the appellant argued in the event wore the mask, entered the home with Becky, and remained present during the shooting. Those actions amount to clear assistance and encouragement. The judge's phrasing may have been clumsy, but it did not mislead the jury in any significant way during the strength of the evidence. His continued participation satisfied the test of intention to evade. If I cannot further assist, I will turn over to my co-counsel, Mr. Sean Slater, who would be addressing grounds 3 and 4 of intoxication and duress.
All right.
May it please the court, my name is Sean Slater. I appear on behalf of the respondent, the King. I am going to present points 3 and 4 of our rebuttal. On the ground of intoxication, murder is a specific intent offense. Voluntary intoxication may only negate intent if it renders the accused incapable of forming mens rea. For this point, I will be referring to the case of R. and Howie, 1987. It states that jurors should not be available as a defense for murder, whether the accused is the principal or an aider and abettor.
Sorry, counsel, have you moved on to duress or are you still on intoxication?
Oh, wrong case, sorry, I apologize. Okay, DPP and Majewski, 1977. Where a specific intent is required and the defendant's intoxication prevents him from forming it, he cannot be convicted of that offense, said by Lord Elwyn Jones at 473. Shane admitted he drank for courage, demonstrating awareness of the plan and its consequences. the jury was properly entitled to conclude that intoxication did not prevent intention and no misdirection caused unfair prejudice. Sorry. Okay, I will now be moving on to my second point, duress, the grounds of duress. It is firmly established in Howe and Gotts that duress is not available as a defense for murder. If it were a case of manslaughter, that would be very different.
Yeah.
The case of R. and Howe, 1987, duress should not be available as a defense to murder, whether the accused is the principal or an aider and abettor. R. and Gotts 1992 says, if duress is no defense to a charge of murder, it ought logically not to be a defense to a charge of attempted murder. This further solidifies the decision of the judge. Even if Becky threatens Shane, the law does not recognize compulsion as excusing participation in intentional killing. The judge's remarks properly emphasize the legal principle. The defense was rightly excluded. Unless I can assist the court further, I would like to. I'm finished with my points.
In relation to your argument on defense counsel, the judge's language, this is a murder case. Would you consider that to be sufficiently dismissive and potentially unfair?
No, because I feel as a judge, he understands the law enough to not misdirect the panel and just give his actual expertise and not opinion, because the law is based on facts, not opinion.
And
Just-
since
Go ahead. The judge is also human, you know. Can make errors.
Well, that's why we have appeals.
I see. All right.
Can I ask you, counsel? Can I ask you? You made, I believe your position is that duress does not apply to murder, whether as principal or accessory. Do you think that the judge should have left duress to the jury to avoid bias, even if it's excluding law?
I do not think so, because the judge, he relied on the law, and his decision was based on the law, so it was correct.
Just one more question on duress, counsel.
Okay.
When you look at the judge's direction, what specifically in the direction could you point us to where you see that the direction was clear to the jury that duress is not allowed under the law for murder?
Can you repeat
You
that?
have the transcript before you?
Yes, please. Okay. 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 So can you repeat the question, please?
I asked you if you could draw my attention, the panel's attention, to where in the direction you're saying that it is clear that the judge properly directed the jury.
Oh, okay. Where do I have the cases?
From your transcript.
Why don't I have the cases here? This is it. I cannot answer this question at the moment. If I could pass the question to my counsel.
Yes, of course.
Yes, that's in order.
Yes, yes.
Yes.
Hello again. Can you repeat the question one last time, please?
The question is in the transcript.
Yes.
Judge's transcript as to the direction that was given. If you could draw the panel's attention to what part of the direction you see was the proper direction as to duress. Have a look at your transcript and then tell me where you see that.
Unfortunately, Your Ladyship, I do not have my transcript present with me.
Okay, let me read it for you. I have it.
Thank you.
Now he says he was compelled to take part by threats. But he knew all along, didn't he? He admitted that he knew Becky had a violent past, and it is reasonably foreseeable that she would have violent associates. Shane cannot associate himself with a known criminal and induce duress as a defense when she resorts to her known violent ways. In murder, duress is no defense anyway, and this is a murder case, not a manslaughter case, nor anything else.
Does one of your colleagues have a copy
Yes.
of the transcript? There, your colleague has one. It's always better to see things with our eyes sometimes than to hear.
The question one more time, please.
Have a look at the
I-
direction, yes.
yes.
I want you to point specifically in the direction where you are saying that the judge properly directed the jury on the issue of duress.
The judge properly from stating that, but he knew all along, didn't he? He admitted that he knew Becky had a violent past and it was reasonably foreseeable that she would have a violent associates. Sean cannot associate himself with a known criminal and induce duress as a defense when she resorts to her known violent ways.
All right, thank you.
I will turn back over to my co-counsel to give the prayer of relief.
Yes, all right.
My lords and ladies, for the foregoing reasons, the respondent respectfully prays this honorable court to affirm the safety of the conviction for murder, dismiss the appeal in its entirety, and grant such further or other relief as the court deems fit. That is it.
All right. Thank you, Counsel.
You're welcome.
Counsel for the appellant.
My lord, my ladies, the claim that Shane has awareness overlooks the content of coercion and diminished capacity. Foresight is simply knowing that the act may occur. Intention is committing the act with direct purpose. Awareness of Becky firearm does not equate to endorsement of its use. The respondent misapplied Georgie as it tightens the standard of joint enterprise, where foresight acts as evidence and not proof of intention. Becky's actions went beyond what has been tactically agreed upon. It is a fundamental change to the joint enterprise. That ends my submission.
Yes. Yes, counsel.
The claim that Shane had intent to kill his wife Stacey, I challenge that by saying that he was too drunk to have the correct mens rea to form a proper intent. Shane never admitted to drinking for courage. He drank due to the threats from Becky.
Yeah.
Duress is accepted as a defense for an accomplice of murder in the case of DPP, DPP Northern Ireland and Lynch. Yeah. That's it.
That's your submission, counsel?
Yes, please.
Yes, thank you.
My lords, on the rebuttal of foresight versus intention. While foresight is not simultaneously as intent, the law following R.V. Woolen 1999 recognizes foresight of death as a virtual certainty as compelling evidence of intent. And in the transcript, we can see that Sean knew Becky carried a real firearm instead of the fake one, and he still went along with the plan, knowing that it inevitably would lead to the death of Stacey. On the rebuttal of participation, Becky went beyond the plan. She decided to get a real firearm, and she decided she wanted to murder Stacey instead of just scare her out of the house. Sean knew this, even though on the case of intoxication, he drank to get courage. He still went along with Becky. He still wore the mask. He still went to the home, and he still was there next to her when she shot Miss Stacey, leading inevitably to her death. That's my rebuttal.
Okay. My rebuttal on intoxication.
Yeah.
Voluntary intoxication is only relevant if it prevents the formation of intent. The judge rightly reminded the jury that intoxication cannot be used as a shield for deliberate wrongdoing. The evidence refuted incapacity. Shane admitted he drank after Becky threatened him and to calm his nerves. This demonstrates awareness of what was to occur, not incapacity to form intent. The jury was entitled to conclude that Shane's intoxication did not nullify his intent. His participation in a coordinated home invasion with masks and weapons strongly indicates deliberate choice. On the rebuttal of duress now. Duress is no defense to murder. The appellants, they refer to the case of Lynch. That was overruled by R. and Howie in 1987, so it no longer stands. Duress is no defense to murder. It unequivocally excludes duress for murder, even for secondary parties. Lynch was expressly overruled on this point. The judge's direction reflected this settled law. By stating that in murder, duress is no defense, the judge properly applied the principle. Even if duress were available, it would fail on facts. Shane had ample opportunity to withdraw before entering the home. His compliance was not immediate or unavoidable, and his later drinking does not convert voluntary participation into compulsion. That is my rebuttal.
Yes. All right, thank you, Counsel.
Counsel, could you remind us of your name, please?
Bilinji.
Pardon?
Yes.
Ashanka Bilinji.
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 Yes. And
The next one is Monroe. The next one is Monroe.
Mefia Monroe.
thank you.
And can I have yours, please? I'm sure you could say it loud enough. Oliver.
And Sean Slater.
Yes.
Slater.
All right. Retire now. All right, Counsel, at this time, we'll retire to consider this appeal. Okay?
Court rise. Supreme Court in its mock appellate jurisdiction now raises for a few minutes.
All right. Well, I remember my first time ever mooting in law school, and I remember trembling until the podium was shaking off its feet. And when I saw these young people putting their hands in pockets and holding on for their life, I know exactly that feeling. So I'm so very proud of them. Please, now that the judges are out, we can give them a round of applause. And we're inviting them to come to be interviewed. Frederick's Attorneys has sponsored this event, and I want to say that we will be doing this again next year for sure, because these young people do need this kind of exposure, and we'll give them all the blow-by-blow tricks of the trade, like walk with your paper, walk with your authorities, walk with your fact patterns, highlights, know how you're guiding the judge, where you're taking the judge to when you want them to consider the case and what from the case you want to consider. Some of these little tips that I know they're prepared, and it was clear that they're prepared, but some of these little tips when you're trying to convince a judge to understand how the law applies to your client as appellant and respondent in an appeal. Those are the little things that you wouldn't know, but they're well on their way. Just as an aside, to those persons who are here present, refreshments will be provided because we've been here from 1 o'clock, and those counsel who are giving me the thumbs up from in the gallery, they went through lunch and are here supporting this this Law Week event. So yes, lunch, finger foods will be provided, but the finger foods is plentiful. Don't worry about it. We have prizes for all of the participants. Will be acknowledged. The successful memorial for the team that writes the winning memorial, they get a prize, and for the winner of the best speaker gets a prize, the best oral arguer, oralist, gets a prize, and the overall winning team, they each get a plaque. The intention really is to spread the competition through schools. The challenge is that the fact pattern speaks to the law. So you don't want to place a high school in a situation where they have to do a crash course in law to be able to participate. So perhaps we extend the competition to other teams coming from the community college and expand the competition. But I'm very encouraged by what I heard today, and we look forward to this continuing next year. The open mic, there is an open mic, and you know we have plenty lawyers in the house, so come and talk the things. Remember, the law still applies, and we are streaming live, so keep it within the confines of and context of what is happening.
Well, actually, Mademoiselle Frederick, we're doing some interviews. Right, so remind us of your name, please.
My name is Sean Slater.
Rain Oliver Gill,
And let us know, who are you representing in this competition?
Cape Law.
Cape Law. Could you just briefly tell us about your experience, like from preparation to actually coming here today? Start, Rain.
Well, with preparations, we did have a lot of time over the 2 weeks. When we found out, we were kind of nervous. We were like, going up against a panel of judges, in front of a lot of lawyers, and in front of, actually we found out very recently that it's gonna be live streamed, and it was very scary, because like everybody, including the folk from the school, was like gonna see this and see us here. It was a little scary, a little nervous, and actually getting into the courtroom and sitting down and realizing this is what we're gonna have to do in the future as when we become future lawyers. You tend to realize you can't be nervous now. You already reached this far, you have to go through and get it done.
Well, we had a lot of time to prepare, but still we were so nervous because this was an experience. It was an opportunity that we could not turn down. It was one that we had to make an impression with. It was just very exhilarating, actually. When we came into the court, we were, as I said before, nervous, but as the court proceeded, we came into our senses, you know? It's not really that special. We're just going as normal.
Well, that's, as you said, that's not very much special. But let me ask you something. Was there someone who assisted you in preparing for this moot today? You can say yes or no if you had assistance, but is the acting DPP?
Well, our teacher, Mr. Udo, he helped us. Mm-hmm. Yeah, he was our only help during this.
Well, he's your law teacher, so he ought to be helping you. All right. So let me find out from both of you. How did you find the questions from the judges?
They were a little difficult. They were really, you had to think them over, yes. It was difficult, but when you finally understood and you got your information together, you really threw to the questions.
It wasn't as terrible as I thought it was going to be. I thought it was going to be very bad, but it was manageable.
Okay. So my last question to both of you would be, after today's experience, are you looking forward to becoming a future advocate?
I'm very much looking forward to becoming an advocate.
Most definitely.
Let me ask both of you, what is your area of interest now? I mean, I know you did this on criminal law, but what really is your interest? Is it criminal? Is it civil? Is it both? Because the majority of practitioners in St. Vincent are generalists. You have very, very few persons who are specialized in a particular area of law. Although I must say, though, the majority of lawyers who are practicing are civil practitioners as opposed to criminals. So I hope you're going to tell me you want to be a specialist in criminal law.
Actually, I do want to be a specialist, but in environmental law. So I'm not staying inside criminal or civil, but I want to expand the boundaries and go into other areas of law.
Unfortunately, I want to be a civil lawyer.
I think he wants to go into the area where they make the money. Is that
Very
it?
much so.
I want to thank both of you very much. I also want to, give you some more encouraging words as you are continuing your studies at the A-level college. And as I said before when we started, let the best advocate win. And thank you so much for participating.
Thank you.
All right, so we have the two ladies team. The other team was male and female, and you are representing. You can start with you.
Hi, my name is Mefia Monroe, and I am representing the paralegal class. Hi, my name is Ashanka Bilinji, and I am also representing the paralegal class.
Right. As I asked the other team before, could you just give us a bit of idea of your preparation, what it took, what your experience felt like? Was it an easy preparation, and as well whether you were given any assistance?
The preparation, it was easy, hard-ish, getting all the information and trying to memorize everything, summarize everything. But thanks to my lecturer, Mr. Max Holder, he was very helpful, and my counsel, Ashanka Bilinji, she as well was very helpful. I am grateful to have the opportunity to come in the court and Moot for the very first time. I am and was very nervous. The judges asked a lot of questions, but as I said, I am very grateful for the opportunity.
Before I ask you that question, how did you find the questions from the judges?
They were challenging.
They were challenging.
Yes, they were.
All right, so let me move on to this other young lady.
I would say preparations were moderate. We got some time to practice and we gathered information. The most challenging part was memorizing, because we had to make sure that we got every word correct and stuff like that. The experience was nerve-wracking, but I think we handled it moderately. The questions from the judges was intense, but we got it done.
Okay, you can hold it for a moment. You said you're studying, but we're ready?
No, I just wanted to share the rules.
Okay, yes, as soon as. You do paralegal studies. You want to tell us a little bit more about that? I know the other students are Cape Law, and usually, my understanding of that would be that they're undergoing an area of studies at the community college to enable them to study law at UE when they're finished. Could you tell us a little bit more about your program?
We actually do the same things, but with our area of study, I think there are more options because we can choose to be paralegals, we can choose to be clerk. It doesn't technically have to be a lawyer or a judge or some.
So, do you know if after you complete, how long is your program?
It's 2 years.
2 years. So after the 2 years, do you know if you're able to apply to
Yes,
UE
please.
to get into law?
Yes, please.
Okay, great. One moment, Miss Frederick. Right. They're not coming back right now. I don't know, but anyway. Okay, yes, of course. When we are finishing, Miss Frederick will be telling the audience about the rules. We didn't get a chance to that before. But before we say goodbye to both of you, I want you to let me know whether or not you're looking forward to becoming a future advocate, and if you are interested in studying law in the future, what area of law you have an interest in.
Well, I am interested in studying law, yes. There is a wide variety of different types of laws, and I am yet to make a decision. But the two decisions I'm right up now stuck between is criminal and family law. I'm interested in studying civil law because I feel that seeing as there's a wide variety of these practitioners in St. Vincent, I'll be able to get accurate guidance.
But the last thing I would say to both of you, as I told you others, Vinette, I'm giving you the microphone. I have to always make this plea to encourage young people interested in studying law to study criminal law. We do have a very, very serious shortage across the region in St. Vincent and Grenadines. So please have a serious interest. And you can do at the private bar as well as you can do it at the public bar. Could be a prosecutor, you could be a defense attorney. Well, all the best, and may the best team win. And thank you so much for coming. Over to you, Ms. Frederick.
You sound good there. I'm just going to say, we sound like we planned this thing. Just for the benefit of those persons who are wondering how this is going to be judged. Teams will be awarded points for their ability to present the case of their side before the distinguished judges. You have 25 to 30 minutes of speaking time, split equally between each team, and further divided between team members as they see fit. So you heard them say they will first be presenting 5 minutes on this side, 5 minutes on that side, and so on. Counsel for the appellants will speak one after the other, and then counsel for the respondents, and so on. Teams are not limited to the arguments they presented in their written submissions. You will not be allowed to just read your submissions. So I heard one of the young ladies say, she spent a lot of time memorizing because you can't just read. Judges will ask questions, but you should not let that scare you. Once you prepare well, you will be able to handle the questions. Everybody was scared. So it was a level playing field. Everybody was nervous. Do not let questions asked by judges distract you from the point you're making. Yes, the judges look big and bad, but they just want to be guided on the law by you so that they could understand why you are saying the appeal should be allowed, why you are saying the appeal is safe and should not be allowed. And one of the things that you have to always remember when you're appearing before a judge, don't get distracted, don't get carried away. You always need to present in a logical and organized fashion, explain the issues, apply the law, and persuade the judges to the view that the law applies to the facts in the ways you have pointed out, and that your conclusion is sound. So the judges have gone, they have this document, they have all of the memorials, and they will sit down and they will arrive at their decisions. So we take a break at this point and wait on the judges. Over to you, ITFX. And just a disclaimer, any music that you hear is for entertainment purposes only and not intended to infringe anybody's copyright. Okay, big and bad with Lada. Paul, just allow me. I see some lawyers. I see some lawyers in the. Gallery. Counsel Akin John. Elizabeth Law Chambers. How was today?
Today is a wet, rainy day. But beyond that, I think this is a tremendous initiative. I think we should all commend the participants. It isn't easy for them. As they indicated, a lot of time was spent preparing, but nothing prepares you for the reality of actually appearing in court, memorizing, but also being able to present, appreciating the formalities of the court setting, and responding to the questions by the judges. What I noted is after you had made your submissions, you were very, very, very quick to take your seat. You didn't anticipate that those questions would be thrown to you. But this is one of the things about the realities of practice. You have to expect the unexpected. Understand your brief, inside out, back to front, front to back, every possible direction. But no doubt you have learned. And again, we commend you for a tremendous effort. I know that this experience will remain with you on time immemorial. Thanks.
This place used to be a bank, so I don't mean I know me lost now, right? Trying to find these lawyers. Everybody has gone to a location now where you can't find them easily. Yeah, but I won't go by them because Chelsea trying to hide and Richie trying to hide. Yeah, coming around there by the door. That's what I'm doing. Yeah. Ta-da! Yeah, wait, don't show me Richie. Counsel Chelsea Alexander of Alexander Law Offices. What are your thoughts?
Well, I must commend the teams because it's not easy getting up there and speaking before 3 judges. Everyone looks very intimidating, but you handle yourselves well. So I must commend you for that. And I will encourage you to keep competing in these competitions. I didn't compete in mooting competitions while I was in school, and it's something I regret. I don't regret it too deeply because then you get the practice when you actually call to the bar. But it's good practice. You set yourself up so that at the point when you're called to the bar, it becomes second nature, right? So keep competing. Don't stop here when you get to university. Take part in these things.
Thank you, thank you. Thank you very much, Counsel Alexander. And right here, next to 2 young attorneys. Sorry, I'm just enjoying being senior to people. Used to be that I would be the junior sitting down until 2 o'clock waiting to have a matter heard, but we have, so I would allow you to introduce yourself, Michaela, to everybody who you are part of the Law Week committee, and of course, your senior, Mandela Campbell Peters, Campbell and Co. So just give us your observations. Oh, you want to say something? Are you're just establishing your seniority? Okay, very well. We'll hear from senior first.
Just briefly to say that my junior has conduct of this matter.
Thank you, Senior, for that introduction. Good afternoon, everyone. My name is Michaela Miguel. I am an associate at PR Campbell and Company Legal Practitioners. I am a baby lawyer. I am recently called to the bar, just 2 years. So it is very good to see young people having an active interest in the law and pursuing that interest. Because I remember not too long ago, I was in that exact same position. It is always important for you to take up these opportunities to practice your advocacy, get used to having to answer on your feet, get used to speaking on your feet. It is always important. It helps you to develop the skills that would make you a better lawyer, a better advocate for your client, and allow you to build the confidence that you need for when you do get to the point where you want to become a lawyer, if that is, in fact, your aspiration. So I would like to encourage you to continue on this path. You did excellent. Just keep up the good work, keep learning your cases, keep up the ambition, and you will excel in whatever you endeavor to do in the future. I don't know if my senior would like to add anything further.
Just to commend you again, and for those who helped you to prepare. And just one one point I would like to encourage you on. When you see the judges there, it can be very intimidating. But always remember, it's a conversation, and think of it as it's a conversation that you're having. You're just having a conversation with the court where you're putting your case forward so that when the judges ask you questions, if you think of it as a conversation, you would listen to what they're saying and try your best to answer it. You're just having that dialogue with the court, and that helps it to be a little less intimidating. But I must say, you are very brave and courageous for having taken part in this moot. So pat yourselves on the back for knowing that you took that step, you participated, and that says a lot. And you be encouraged that, whatever feedback you get, you take it and you implement it. So if you go forward in other mooting competitions, that the best is yet to come and better is yet to come. So all the best to you in your respective careers, and also kudos to Frederick's attorneys for sponsoring this mooting competition. We look forward to more moots in the future.
Thank you. I will pay you for your endorsement later. I'm finding all the lawyers. Now Pat suddenly needed to take a phone call. Okay. Yes, I see Mr. Maitland. Mr. Maitland's telling me there's no seat next to him. So you come right here. Come right here and have a conversation with me. This is Mr. Richie Maitland, counsel, Grenadian counsel, Vinci by association. And what are your thoughts in relation to the moot?
Well, I thought they did pretty well. The first thing I noticed was that it seemed that they were able to stand erect, not fidget. All of those things are important. They didn't use too many filler words. What I would advise them is that you actually become better when you pitch to yourself in the mirror. It's a difficult thing to do, but that's the most extreme form of self-critique, perhaps. And you trust me, you become better. And the one thing that I think could have been improved upon is that you guys have to preempt questions that might come, and so that you're able to respond to them, particularly with authorities. And that's it. Thank you.
All right, well said. Well said, counsel. Listen, this is your first moot. I want to encourage you to keep mooting. I forget that I had to go through this door again to get back wrong in the... Right, and I'm going to find the which counsel am I? Wait, this one is a very new counsel. Y'all need to remind me that we have some BB lawyers who are proper BB lawyers who just became lawyers. Young lady, you were called last week, not so?
About 2 weeks ago.
Oh my gosh, my guess was good. Please introduce yourself to the viewing public.
Everyone, my name is Bimala Thomas. I'm attached to Jomo Thomas Chambers at the moment.
How are you finding practice?
I'm finding it, well, every day it's a learning experience for me. There's always something new to gain.
And what would you say to those young persons who have mooted in terms of, you've appeared before the court?
Yes, yesterday was my first.
Hold on, when was your first appearance?
Yesterday.
Were you nervous?
I was nervous when I first got in, to be honest, but after I rose, I stood. It just flowed.
Right, so you would encourage the young people to keep at it?
I would. Just put yourself out there, gain as much experience as you can, and just go for it. That's what I would say, go for it.
I just feel like, wow, 2 weeks ago you were called to the bar. This is awesome. I was called to the bar 22 years ago, so here we go. There we have it. Nice to speak with you. Right, I'm going back now to find the acting DPP. Trying to run away. Trying to run, but I see your belly behind the banner. I spot your belly behind the banner. He couldn't hide. Yes, Mr. Yeah, you did a runner. You all right? Catch your breath. Catch your breath. Yes. Your thoughts, your words of encouragement, your guidance, your sage wisdom.
Thank you very much, Council. I see that although the Prime Minister says you have to have a lot of guts to live in this country, I can see how it can be an impediment. It prevented my attempt to flee. Now, first off, I'm happy to see that these moots have been revived in the state of St. Vincent and the Grenadines. It's a very good initiative by the existing executive of the St. Vincent and the Grenadines Bar Association, and I commend the executive first, and more particularly so Frederick's attorneys for having emptied their coffers to sponsor. Of course, the extent to which I can commend them on that is pending the review of the financial statement. Thereafter, I have to say congratulations to the 4 advocates who were brave enough to engage in this enterprise. As previously said by my colleagues at the bar, it is a daunting experience to have to face a panel of judges. That said, one always has to remember not only to master one's facts, but to make sure that one is so acquainted with the law that when probed and when prodded by the judges for an explanation to justify the argument that you have before the court, that you are equal to the task. And that, of course, is something that comes with practice, and that as well comes with familiarity with not only a subject matter, but the law. And of course, I am certain that you will only move from strength to strength as you engage on this, your journey, if that is your choice towards a successful legal career. So I say congratulations to all 4 of you. And I must say to Mr. Sean, that was a very deft and skillful move, throwing your co-counsel under the bus when asked a question by the court. That was very skillfully dodged, very skillfully dodged. Over to you, Ms. Frederick.
Yes, word from in the judges' chambers is that they will soon be returning. So let me pull back the microphone, and I invite the members of the president of the bar, well, this is our SOS for the president of the bar. We have things to present. Right, so I'll get back to the lectern and await the arrival of the judges. On order. I'm just teasing. I'll get up in somebody tell me, stop rub doing head. But we are definitely doing this again. With the idea of streaming it and people getting to see what times have changed. Yeah, I think that helped. My clients send me messages and say, look, my lawyer, and take a screenshot of me, make it look like I'm doing this.
My office sent me when you wake up, so I had to say, why are you not working?
Wake up.
So I said, no, so I said, I do not do my
Oh, you respond to me. Come on, ask me something.
It's just going there.
No, but what happened is, that is the con. You send it to her, she have any feedback.
I sent it to her. They have to tell me when she says.
I think it's fair. You're right. I think it's fair.
It came in. I told her.
Lordships, the Honorable President, and the other justices of this mock appeal, Supreme Court in its appellate jurisdiction now resumes.
My lords, in your absence, we apprise the public of the rules and the rubric for how the appellants and respondents were to, counsel for the appellants and respondents were expected to be judged. And we look forward to you giving, of course, some general feedback, and we are advised that you wish to see the young participants in chambers to speak more directly with them and give them their feedback. My lords, I'm just saying on behalf of those of us who have long sat at the bar, Lord, sometimes when you are wont to chastise us, we wish that you could similarly invite us into chambers. I'm just saying, you know, this new approach that you have chosen to adopt in this mock appeal, my lord, it may well find favor with counsel. I don't know.
Well, counsel, we expect that you are well seasoned and that your skin would have thickened over the years, and therefore you would be more than capable of being able to take the brutality.
Yeah, my lady. Yeah, my lady, I'm just saying, you know, if you are minded to extend that same courtesy to counsel, we would not object.
We'll consider that, Counsel Frederick. All right, thank you, Lord Counsel. All right, my sister, Justice of Appeal, Dantes, will give the decision of the court.
This is the appeal of Shane Beckford against his conviction for the murder of his wife, Stacey Beckford. 4 grounds of appeal were advanced: alleged misdirection on the issues of intention, secondary liability, voluntary intoxication, and duress. Having reviewed the transcript and the competing submissions, both written and oral, this court finds no material misdirection that rendered the conviction unsafe. The appeal is therefore dismissed. On the first ground, The appellant contends that the trial judge erred in directing the jury that they could infer intention if Shane must have known the death or serious harm was probable. When viewed in context, the direction was consistent with the principle in R.V. Woolen that foresight of virtual certainty may be treated as strong evidence of intent, though not synonymous with it. The judge did not collapse foresight into intent, but invited the jury to infer intent from the evidence of the appellant's knowledge and conduct. Given Shane's awareness that Becky possessed a real gun and his continued participation in the plan despite that knowledge, the jury were entitled to conclude that he intended or at least accepted the fatal consequence. There was, therefore, no misdirection of law or intent. On the second ground, it is said that the judge erred in law on joint enterprise by treating foresight as sufficient for participation. This court accepts that R.V. Hoagie clarified that mere foresight does not equal intention to assist or encourage. However, in this case, the appellant's conduct went beyond passive foresight. He jointly devised the plan, entered the house masked, and accompanied Becky throughout the commission of the offense. His continuing presence, knowledge of the real weapon, and failure to withdraw all demonstrate that he was an active participant who intentionally assisted the crime. Any imperfection in phrasing did not amount to a material misdirection. Turning to voluntary intoxication, the trial judge's directions must be read as a whole. The charge made clear that while intoxication can, in principle, negate the specific intent for murder, it cannot serve as a shield when a defendant deliberately drinks to fortify his resolve. The jury were properly invited to consider whether Shane drank to give himself courage or because he had lost control of his faculties. Their rejection of the intoxication defense was open to them on the evidence, and no miscarriage of justice arises. On the final ground, the appellant relies on the defense of duress. The law is settled that duress is no defense to murder, whether for principal or secondary party, as held in R.V. Ho and reaffirmed in R.V. Gotts. The judge's statement that this is a murder case, not a manslaughter case, nor anything else, correctly reflected the law and cannot be faulted. In the result, while the trial judge's directions may not have been models of linguistic precision, they adequately and correctly conveyed the law. The jury had the benefit of all relevant evidence, and their verdict was open to them on a proper view of the facts and law. The conviction is therefore safe. Accordingly, the appeal is dismissed, and the conviction for murder is affirmed. It is so ordered.
You have to say obliged.
Get up and you say
Say obliged.
Everybody.
Get up and say
Get
obliged.
up and you say much obliged.
Yes, thank you, counsel. All right, Justice of Appeal, De Silva, Mackenzie.
Dissent.
Yeah.
As regards the person who came out on top, or should I do the team first? The teams, as may be evident from the ruling, the respondents for the winning team on the written work, and as regards the orals, Ms. Oliver Gill was the top performer. Congratulations.
Yes, we invite the court to go ahead and read the results, and then we'll do the presentation. Oh, she
Want
does
more from the results?
Oh, very well. No.
Oh,
So
okay. I didn't think
each-
you wanted the details. We didn't think you
No,
wanted
no, no. In relation to the written.
We have given all
Oh,
of
we
that.
gave those.
Right.
Yes.
Okay.
All the results were given, counsel.
Oh, very well.
Yes.
Very well.
So are we allowed to retire now? Okay.
We expect the quorum to give a result as to the best memorial. So
Did that come
Isn't
through?
that the written? Isn't the memorial
yes,
the written? Yes.
and
we
then
did
with
do
the
that.
best oralist.
All
Yes,
that
we did that. So
Council?
Okay.
Council Frederick?
Miss Frederick wasn't paying attention.
All right.
The best memorial
Yes.
is the one that came from the respondents. Is the team.
Okay, so the winning team is a team for the respondents.
Yes,
And much
Council.
obliged.
And as regards the oral,
Yes.
Yes.
the winner is Miss Oliver.
Oliver.
Very well.
Yes.
All right, so we invite before you retire, judges, we know that we took your time from the real world of the courts. We know that we took your time these last 2 weeks, and so we did not want you to leave this competition empty-handed. I will invite the member of the bar, one Dwayne Daniel Esquire, my senior.
Are we allowed to see Mr. Daniel? Is he properly attired?
Yes,
for the
well,
court?
yes, for the purposes of the moot, he actually, he cannot be heard, but he can be seen. As a matter of fact, some may say he can be missed. He is properly attired in African wear, which, may be an alternative in the years to come before these honorable courts. So we invite the president of the bar as well to come, because you have to read which merch goes to who. We have a merch bag. Apparently, this is the way you do things properly in 2025. Some particular goodies to, when you think of how much we terrorized you these last 2 weeks, you'll say, but I have this merch.
I would just like to register certain ethical considerations with giving gifts to the judges, but I'd also like the advocates here to realize a contract point, even though this is technically speaking criminal proceedings, that past consideration is actually not good consideration. So the ethical consideration aside, I think contractually we are sound.
I'm guided, my friend. So we invite Justice Snack Dantes to please come forward to receive your gift with our sincere gratitude.
Do I jump over?
Oh, you have to go around.
No, wait, they can't come around? So this is what we do, so Dwayne will come up. Yeah. Psst. Hello. Hello. And the president of the court, Justice Ricky Burnett. Right. Thank you. Thank you, thank you, thank you. And to the senior magistrate, the Honorable Tamika Mackenzie, the Silva Mackenzie.
Can we acknowledge that you got to skip from magistrate's court, past high court, and straight to the Court of Appeal?
Yes, yes, she has been elevated and then elevated. Thank you so much, thank you so much. You can, if you choose at this point in time to retire, although we had hoped that the president would make the presentations present the winners.
Well,
With
let's do that, and then we can retire with
them.
the ladies and gentlemen.
Yes. All right, so the participatory certificates for everyone. Maxon. Oh yes, we have to set up for the optics. All right. Yes. Yes, and yes. So you could read what it says and to whom.
Right, so the first certificate is to Rain Gill for spirit participation in the inaugural J.H. Bayliss Frederick Memorial Moot Court Competition, October 10, 2025. Well, she wants to make sure that we have that.
Nice. Right.
We will now have Sean Slater says the same thing on each certificate.
You guys could clap, we're not in court.
Miss Monroe, is it Mephia? Mephia Monroe, you're next. For your spirited participation in the inaugural JHB Bayliss Frederick Memorial Moot Court Competition, October 10, 2025, which is today. And our last team member here today, Ashanka Bilinji.
Next memorial. I was just saying that the judges need to practice because we're going to be doing this every year. Just saying. I just foresee myself getting into so much trouble for this next week when I have a trial before said judges. Yes. Justice Sanak Dantes, we're asking you please to present the trophies to the individuals and the
Right, so this is the best oralist, which is Rain. Rain, what's your last name again?
Oliver Gill.
Oliver
Gill. Please go next to the optics. Thank you very much. Yeah. I think Justice Sanak Dantes is a little bit too natural and good with this. Yes. Yes. The respondents. Yes. And the team that had the best memorial, both members, representing Cape Law. Wonderfully done. And the winning team, yes, Justice Santos, the winning team, Cape Law, each individual presenter gets a plaque which and we thank you. Thank you so much, Justice Dantes, Snack Dantes, and thank you to all of the participants here this afternoon. Of course, there are refreshments, so do not disappear. And we will like a group shot, and the judges will speak with the participants, all of the participants in chambers.
Let's do the photographers.
Yes. Yes, we have no idea how to do this. This is the first time we're doing this, so. We just need to not, Yes, we need the judges to be the least inconvenience. Everybody else catch. Don't sue the state.
They're going to stand there.
Yes. And 8 Images is doing the still photography. Let me just give everybody a plug. Dwayne Bailey. 8 Images doing the still photography. You guys go. Yes, 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 and yes.
More balanced, yes.
Right.
You don't want the visual?
Yes, you're in the way of this on the side. This is making for wonderful TV for the people who are seeing the live stream, and I'm just saying. Paul, choose another camera for the live streaming. Yeah, seeing the dock and the wire. Wonderful. Wonderfully done.
And then you and I should stand on each side, the president and
Yes. Please don't move. Allow some time for paparazzi because the sponsor's representative and the president of the bar wants to not be left out of the photography. Yes.
Mr. Holder doesn't get in there when he did so much work.
I'll come for the last one. The last one.
Yes, the chairperson of the committee who really pushed to make the entire week a success. And tomorrow we go to River 14 to decompress. We invite you to join us at River 14. There's a financial contribution to the effort for those who are listening to me, who want to come.
Yeah?
Ms. Frederick, that's it? We can
Yes, and we ask the youngsters to accompany them.
Yes.
Oh, wait, we need to close the court. We do need to close the court.
Well, look at that. We should have done that before the powerful.
You have to sit down first. Okay, tell us when. Okay.
All rise. Supreme Court in its mock. Supreme Court in its mock setting. Now stands adjourned, sign the line.
We just want a picture with the executive. Well, who's here of the executive? Come.
You didn't send it by WhatsApp. Oh, no, I haven't seen no picture. Maybe you sent it by some other one because I have not seen the picture in the chat. Yeah, extra large. No, they're all the picture of the woman on the it's different in terms of